all on the behalf of Lawful Legal. The subject matters for today's webinar is on Advanced Legal Drafting course, and the resource person for today's webinar is Deeksha Tewari ma'am. I would like to introduce Deeksha ma'am. She is an assistant professor of law with more than 9-year plus experience in the field of legal drafting. She holds a bachelor's degree in Bachelor of Arts and Bachelor of Laws honors, BA LLB honors, specialized in corporate laws and LLM. She also specialized in labor and industrial relations, PGD in labor laws and management. Doctor of Philosophy, PhD law pursuing. So without taking much time, I would quickly like to introduce the organizer of today's webinar, that is Lawful Legal. Lawful Legal is more than just an online platform. It's a getaway to making law accessible to everyone. Our mission is to provide comprehensive notes on various legal subjects, ensuring that the intricacies of law are easy to understand for all. At Lawful Legal, we believe in nurturing the legal minds of tomorrow. That's why we offer a range of opportunities for students to develop holistically. Our vision is to elevate the legal professions to new heights. We aspire to create a gurukul of legal knowledge where acts, rules, regulations, codes, and orders are not just studied but understood deeply. We aim to empower the legal community, ensuring that the legacy of legal excellence continues to thrive in our society. So, without taking much time, over to you, ma'am.
Thank you so much for my brief introduction. Hello, everyone. So we are here with the advanced legal drafting course, and today I'm going to briefly discuss what we are going to do in this particular course and what all module plan, what all things we include in our module plan for your better understanding of how to draft, what to keep in mind, how to go ahead with legal drafting. When you talk about legal drafting, one most important thing that you need to keep in your mind is drafting all the legal intricacies with full awareness that it will have legal consequences. So there are some do's and some don'ts that you need to have basic understanding of, and accordingly you will have to create any legal document that is there, be it plaint, be it written statement, be it pleading, be it your notice, be it your summons, whatsoever it is. So while drafting all the legal documents, you need to have few things in your mind so that you have clarity as to how those whatever paragraphs you are going to include in your drafting, in your legal drafting, it will have legal implications on your clients. So you need to have that particular thing in your mind while drafting a particular course, particular document. This module plan is obviously based on advanced legal drafting, where we'll be having hands-on experience while drafting while learning various drafts. We will also be having a situation wherein you are going to draft legal particular document that is going to be given to you as an assignment during the module plan. So the course on advanced legal drafting aims to equip all the law students and legal professionals with a particular skill in drafting legal documents like wills, affidavits, contracts, agreements, pleadings, alternate dispute resolution, say for example, arbitration agreement, mediation, conciliation, and the course covers various aspects of drafting, which will include the language, the structure that you have to have, the clarity and the precision that you are required while drafting any legal document. Participants will also learn how to effectively communicate legal concepts, negotiate terms, and avoid common drafting errors. The course will provide hands-on experience to improve your drafting proficiency and legal writing skills. So in totality, a law student or a professional of law will get a better edge from all those who are not going to be participating in this particular webinar or in this particular course. So for better understanding, while we talk about the module plan, the module that we are going to take forward for learning the advanced legal drafting course, it is very important to have learning objective or learning outcome to better understand what we are going forward with. So we need to understand the principles of legal drafting that includes clarity, precision, conciseness to help your client represent better, develop proficiency in drafting legal documents such as contracts, pleadings, and legal opinions, because these documents will definitely in future have legal implications on your client. The third point that we will aim towards the learning outcome of this module plan will be to gain knowledge of the importance of using a plain language in legal drafting. You all must have read the subject law and language in your first year or in second year as your legal English subject, legal English 1 or legal English 2. Usually this is taught. Why it is taught? Because ultimately it will help you in drafting all your legal documents. So while you are studying legal English, you can also refer all those things. You must have read all the acronyms that are there that we use, the legal terminologies that are used in the courts regularly. A few things like dakil kharij, like registry, registers, like signing room, those rooms where all the legal documents are there, all the files are there, khata room, and all those things. So all those, you need to understand the meaning of all those Hindi terms that are there in the court while you practice in any of the district court or in maybe high court or supreme court. In high court or supreme court, usually the language is English. But while you say you are practicing in a lower court or maybe a district or a session court, you will be encountering both the languages, that is English and Hindi. So you need to learn the techniques for effective communication in legal writing. That includes how to structurize, what things to come first, what things to come next, and how the document is being framed. What is the organizational structure, what is going to be the tone. Say, for example, when you talk about agreement, arbitration agreement, the tone is going to be on a different level. Say, for example, when you are drafting a claim, the tone that you are going to use, the language that you are going to use will be a little different. So you need to learn those techniques, that how and what sort of words you should be using in order to communicate better what you require or what your clients are requiring from the other party. So you need to identify some common drafting errors that are there. Usually people don't understand what sort of tone should be used, or what sort of communication or writing things should be done. So there are drafting errors, and you need to learn those drafting errors in order to avoid them in documenting or forming a document that is there for legal document that is there for your representation of your client. You need to develop critical thinking, and this particular course will help you develop. Why? Because while teaching you a particular draft, I will also be giving you a situation wherein you will have to create a document, legal documents. For example, while teaching you commercial contract, how you are drafting it, I'll give you a basic contract that is going to be drafted, and then will make you learn through providing you a legal scenario, a situation wherein you will have to apply your brain, whatever laws you have studied in the contract act, and then formulate a particular document for the same. So this way, I'm going to go ahead with all the module, and the module 1 will be dealing with the drafting of the commercial contracts. There are going to be 5 modules in this particular course. And while we talk about module 1, that is drafting commercial contracts, we will just have a basic introduction of what is contract. We will discuss some definition, how contract is formulated. As you all know, you must have studied Indian Contract Act 1872. What are the essentials of a contract? Everyone should be knowing it. Kinds of contract, then what is the distinction between an agreement and a contract, and then thereafter we will draft contract or draft agreement. We will have those things. We will draft key commercial contracts, say for example, copyright, lease agreement, settlement agreement, etc. So this is going to be our module 1. And this is the way we are going to proceed ahead further with our module 1. Then when we talk about module 2, it is all civil drafting. We will just go through Civil Procedure Code 1908 in a very, very brief manner. We will understand the jurisprudential essays, and then we will move ahead further. I hope I am audible. Please, if anyone can let me know.
Yes, ma'am, you are audible.
Okay, thank you. So in module 2, we will be having civil drafting, wherein we will initially have a discussion on the basics of civil procedure codes. What do you mean by plaint? What do you mean by return statement? Which section, which schedule talks about it? What are the contents of the plaint? Order 6, Order 7, Order 8, Rule 1, Rule 1, Rule 1. And how are you going to go ahead with the particular drafting of those particular plaint, or return statement? And how you go ahead with the institution of suit. How do you institute a suit in a court? So we will have an overview of all those aspects. We will then go ahead with affidavit, which is being provided under Section 2, Clause 26, Clause 2, which says that every suit that has been instituted will be compiled with the affidavit, and affidavit की verification होगी verifications of pleading, Rule 15, Order 6. So we will have a interconnection between the particular laws, and then we will have the understanding of exactly what it is, and then we are going to move ahead further with drafting of all those particular things, all those particular instruments. Say for example, plaint. How will you draft a plaint? So plaint,
Hello, ma'am.
what all things are included in plaint? You need to have a basic understanding of those particular
Hello.
aspects. Yes.
Excuse me, ma'am. Your slides are not clearly visible.
Okay, just give me a minute. I will stop sharing and then share it again. Just give me a minute. Is it now visible?
No, ma'am.
Not yet. Why is it so? Yes, I hope now it is visible to you.
Yes, ma'am.
Okay. So when you talk about civil drafting, you need to understand the basics of what pleading, what do you understand by the term pleading or plaint, on how you need to draft, what is the law that is there. See, when you talk about the practical aspect and the theoretical part, it is more or
Ma'am,
less
still
like,
slides are not visible. It shows a blank page.
okay. Can I just email you once if possible? Because from my end, I am trying to do it, but I think it is like this only. I
Yes.
can see that it has been shared, but I don't know what's the technical glitch that is there.
Ma'am, you are visible, not the other screen.
I am trying to do that as well. Just give me a minute. Is it now visible?
No, ma'am, your picture is visible, but the slides are not.
Okay. From my end, it is being showing that it is visible to all of you. Okay. So I'll be sending this particular PPT to you. Just give me a minute. I'm sending it right away, right?
Okay, ma'am.
Everyone, please wait. Ma'am will join soon. There were some technical glitches from her side.
Legal documents. We will have a basic introduction of what you understand by what is civil procedure code, why was it made, why was it created, what was the intent of the legislature behind bringing in this law, and what was the need to bring this law for the society as a whole, and why do we study it from the legal perspectives. So that's going to be one part. The other part that we are going to have is how what is the first step towards filing your suit. What happens when, as soon as your legal right gets violated, you get cause of action. Cause of action arises as soon as someone violates your legal rights. Only legal rights, not social or moral rights. So, say for example, if you and your friend was having a conversation, and in that particular conversation, your friend asked you, "Will you be accompanying me for a movie?" And you say, "Yes, I will definitely accompany you for a movie." And he brings 2 tickets, one for you and one for himself. Later, you don't turn up. Is it your legal right? Is it the legal right of your friend which got violated? Or was it a social or a moral duty of you towards your friend that you will have to go because you have just made a promise to him? So it will be a moral or a social right. It will not be a legal right that is going to be violated. What do you understand by the term legal right? Legal right is your right that is to be exercised. We have rights, we have duties. If one has a right, the other one has a duty, and if the other one is following a duty, if you have rights, you will also have literally some duties towards other person. And one of the duties, say for example, when you read fundamental rights, when you read fundamental duties, there are certain classes that have been defined by the legislature. So accordingly, you work. And while you say you have a legal right and that right gets violated, there appears a cause of action. वहां पे आप अपना लीगल राइट एक्सरसाइज करने के लिए, कोर्ट से लेने के लिए, यू कैन इंस्टीट्यूट अ सूट, बिकॉज आपके पास एक्शन लेने का एक वजह आ गया है कि आपका एक लीगल राइट था. Say for example, you have a legal right to enjoy free environment, good air, आपको इलेक्ट्रिसिटी मिले, लाइट मिले, जो आपकी सनलाइट है वो आपको मिले. बट क्या हुआ? Say for example, some third person was constructing something, and he constructed in a way that particular building that it is taking away all your legal rights. Then in that case, what is the remedy? You will go to the court to exercise your legal rights. You will maybe file for temporary injunction, injuncting that party from building the particular structure. Prescribing court will prescribe him what is to be done and what will not be done. So how will you go ahead with the drafting of that particular document, particular pleading, particular plaint, return statement? And that is what we are going to study in this particular advanced legal drafting course. We will also have a basic discussion on what you understand by the term sermons, how many kinds of sermons are there. We will discuss and highlight key sections to understand the language of the law, what is being prescribed. Civil Procedure Code talks about both the aspects, the substantive law as well as the procedural law, and how it is being defined. So the substantive law are there in the sections. I know each and every one of you have that idea, and the procedural law is being prescribed in the schedule through your orders, through your rules in those particular orders that you study. So Civil Procedure Code is in a way both the substantive as well as the procedural law. More of a procedure, less of a substantive. You need to have a basic idea of all those things in order to draft any legal document that relates to particular civil proceedings. Then notice under section 80, what do you understand by temporary injunction under order 39 rule 1? Then criminal drafting. We will have in module 3 criminal drafting. Shivansh, can you just go ahead with module 3? Hello, module 3. Yes, criminal drafting. Now, when you talk about criminal drafting, CRPC, what are the provisions of criminal procedure code? When you talk about drafting a particular legal document. So on the very first instance, we will be having a basic idea. Again, jurisprudential essence is very important. You need to have a basic understanding of what it is and why the law was drafted. What has now we also have for CRPC, we also have a simultaneous law that is being now implemented all over, though not fully. But yes, now we are moving ahead with the Bharatiya Nyaya Sanhita. Application for exemption for a personal appearance of the complainant and accused. Then we will draft bail application. Bail application will include both the normal bail, the regular bail, and the anticipatory bail. We will have a brief discussion on the format of regular bail application that is being filed before the Court of Metropolitan Magistrate under Section 437 of the CRPC. We will also go into the details of what this particular section talks of. We will also discuss 439 CRPC, which is the bail provision for the Court of Sessions, then format for anticipatory bail and criminal complaint. How do you file any criminal complaint? This is going to be very crux because usually how you are exempting yourself from personal appearance, that application needs to be written and then it is to be filed by your advocate in person, and then the court, it is the discretion of the court whether to grant that exemption or give you some point of time that you may come and appear in the court, and then the court proceedings will go ahead. Unless and until it is too urgent or rarest of the day, because the court is also these days having a lot of burden of completing the cases within a particular stipulated point of time. They also have targets. So now it is now the practice that has been there of maintaining a bar and a bench relationship is now taking a little bit turn, because when you appear in court in practice, court might because it is the discretion of the court whether to allow you, whether to exempt you from your personal appearance or not. It is totally the discretion of court, and these days courts are going through all the pros and cons of all asking you to come or appear in person and all, everything, and then decide whether they will exempt you or will not exempt you. So it is total discretion. Although in order to maintain a bar and a bench relationship, usually the court allows you. Can you please come to module 4, which talks about intellectual property rights? That is IPR. Okay. When you talk about intellectual property rights, there are going to be various dimensions of it. You will also have geographical indication. You will have copyright law. You will have trademark. You will have patent. But you will have designs law. But in this particular module, I'm going to only discuss the copyright and the key provisions and how you will draft an application and file an application for getting a copyright on certain documents that you have written, you have created by your own wisdom, by your own skill, which is new, which is something which is researched on. Re-searched means you are researching on a particular topic that has already been researched, but in a different way. You have a different perspective. You are bringing something new to the table. That trademark, how you apply for trademark, and there is one DPIIT that that deals with all these particular copyright, trademark, and patent key issues. They by time and again also conduct webinars. If you are more keen into learning all the intricacies, seeing live court proceedings, you can definitely go and join that also. But here also I'm going to put something that's going to be different, and you will get that particular edge on that particular topic. So I'm going to bring in some practical aspects into drafting and filing of these particular applications. Also, we will have this separate discussion on patent, how you file for patent, how you draft for them, and what is the procedure, how patent office works, what is the procedure, वहाँ पे जो patent grant कर रहे हैं, what is their role and responsibility, how they analyze and exercise their discretionary power to give you whether to grant you patent or to reject your patent. So it is a whole process that is there in the patent office that's being followed by the members of the organization, or you can say the people who are working over there. With this, I am now moving to my final slide, which is the 5th slide of the day, which talks about alternate dispute resolution. And when you say alternate dispute resolution, it is altogether one subject that you must have studied. Also, you must have studied the particular provisions in the Code of Civil Procedure, section 82. Sorry, 89. So when you talk about alternate dispute resolution, arbitration agreement, what do you understand by arbitration agreement? How does party come to this particular point of arbitration agreement? Usually arbitration agreement is being followed by those who have entered into a commercial contract between the two parties. Say, for example, it can be a contract between a company, say for example, XYZ company in India and versus XYZES company in USA. How are they going to regulate their legal relationship will be defined by this arbitration agreement. It can be formed as a whole, as a different document as a whole, or it can be included in their contract document itself. So it is the discretion of the parties to choose in which forum they will go for arbitration, how they will conduct their proceedings, who is going to be their arbitrator, and what is the procedure that is being followed by those particular arbitrators. It is all decided by the parties' mutual consensus. Then when you come to mediation, usually mediation, what happens is being taken up for family disputes. You must have visited district courts, districts and session courts. Over there, you must have seen mediation and conciliation rooms, mediation and conciliation centers, come library. In the district and session courts, Gurugram, where I was also practicing earlier while I was not teaching. So there was this particular room, which is known by the name Mediation and Conciliation Center. And over there, you can go visit and have a basic idea as to what all the skills a mediator use in order to bring both the parties to a conclusion. And that particular conclusion is binding between the two unless and until the other party wants to go ahead with the case. Similarly is with the conciliator. What is the important element that a conciliator should have in him or her while conciliating a particular dispute, while bringing the party to a common point, common dicta that now, okay, these both the parties said, okay, we are okay with this particular decision and this is going to be prevalent and binding to both of us. So this is the whole structure that I have made, and it will include and comprehensively cover all the aspects that relate to advanced legal drafting, and the course is like this only. So Shivansh, over to you.
Hello. Hello.
Hello. Hello, am I audible?
Am I audible, ma'am?
Yes, you are audible.
Hello.
Hello. Hello, am I audible?
Yes, ma'am. It was a great session. Thanks a lot for today's webinar.
Thank Thank you, Asa, for
Uh,
giving me this opportunity.
if anyone has any doubt, please ask your doubt in the chat box.
So I'm really sorry for the voice issue that is there, glitches. I request the organizers to please convert from Zoom to Google Meet. That is a better way of communicating with the crowd on an online platform.
Ma'am, participants are asking some queries in the chat box.
Okay, can I see all those messages? Hello, I can see that people are. It's a 6-week course. It will start from 25th of May. We will have our classes on Saturdays and Sundays from 7 to 8 p.m. Is there any other doubt that is there between in the minds of our participants? Course fee is 2,500. Yes. You may please join us for the particular course. Okay, so what is the difference between mediation and conciliation? See, there is a thin line difference between the two methods of resolving the dispute. That involves a neutral party, which is not biased, which is unbiased. In the conciliation, what happens is third party will give you a probable solution, but in mediation, both the parties, that is dispute, जिन parties के बीच में है, वो खुद से एक बीच का रास्ता निकालती हैं और डिसाइड करती हैं. उन दोनों में यही डिफरेंस होता है कि कंसिलिएशन में आपको जो पका पकाया माल है वो कंसिलिएटर दे देगा. वो आपको बोलेगा कि ये सोल्यूशन है मेरी तरफ से, आप दोनों की बातें मैंने सुन ली है, आप दोनों की बिहाफ पे मैंने ये फैसला किया है. दोनों की बातें सुनने के बाद ये एक मिडिल कोर्स निकल के आता है. बल्कि जबकि मीडिएशन में ऐसा नहीं होता. मीडिएशन में पार्टीज की सारी बातें कॉन्फिडेंशियल रहती हैं और मीडिएटर ट्राई करता है कि दोनों को एक पर्टिकुलर पॉइंट पे ला दे जहां पे वो दोनों की मिलने की संभावना हो और चीजें सॉर्ट आउट हो. You can please visit my LinkedIn profile. You'll get to know. I'm also running my YouTube channel. You can also subscribe to that. Thank you. With this, Shreyansh, I think I don't have any other questions. I have already answered one question that was related to the difference between mediation and conciliation. I hope the query has been resolved. If not, we will discuss it in our course. So I would recommend you to join my course. Very soon we'll meet again on 25th of May. The course is going to start and we will have our classes. Certificates, please, Shivansh, please let them know about the certificates. Whatever the procedure is, please let the participants know. It will be really a great thing.
Thanks a lot everyone for joining the webinar. Now webinar has ended, so you can leave it.